Hi, I'm Anna Denton-Jones, and in today's session I want to talk a little bit about what's happening with employment tribunal litigation. As a result of the pandemic, a number of different factors have caused a bit of a perfect storm. So whenever the economy takes a turn, then claims around things like redundancies will increase. There obviously will have been an increase in cases around things like health and safety and the way employers have managed COVID. So that will have put pressure on the system. At the same time as things like lockdowns and restrictions that the tribunal services had to follow for their own staff and for the safety of those visiting have meant the way in which cases have been dealt with have been delayed, or there's been restrictions in place that have had to change the way things work. So that in itself causes pressure internally on the tribunal system. So we're seeing cases being listed further ahead in the future. So just to give you an example, it's the beginning of December. I was in a case management discussion this week in relation to a discrimination claim that was issued earlier in the year in April, and that case is now not going to be listed and heard at the full final hearing until December of 2022, so a full year from now. But that doesn't mean that we can all rest on our laurels for a number of different reasons. So first of all, the employment tribunals are front-loading the preparation of that case. So even though it's not going to get heard for another year, I need to be working on it now, straight away. Documents have got to be exchanged in January, so I've got very little time to start to pull everything together for that. And the timetable to prepare the case in terms of things like witness statements, that's all been front loaded. So just because there's a long time until the hearing doesn't mean that we can all do nothing. The other reason, of course, is that if memories are going to fade, it's really important to start to get people's recollections down on paper in terms of their witness statements as soon as possible. One of the challenges for employers where there are those long timescales to a final hearing is whether or not the witnesses, the people who were involved in the particular situation that's being disputed, will still be employed by the time that the hearing comes round. Of course, lots of people are moving jobs after the pandemic, and it's entirely possible that people will have moved on. That means employers are more likely to have to do things like arrange witness orders to get the right people at the hearing, and there's just that little bit more work involved in liaising with somebody who isn't, down the corridor from you. So that's another factor that's coming into play. We've seen paperwork grow exponentially. These days, it's not uncommon for a bundle to include photographs, WhatsApp messages, Facebook posts, lots and lots and lots of emails, of course, because that's something that everybody's using to a great degree now, as well as all of the traditional policies and procedures and letters and things. So the size of bundles is getting bigger. The other thing that's changed is that we are required quite often to produce an electronic bundle. So gone are the days where I just used to be punching holes in bits of paper and filing things in a Lever Arch file. Now documents have to all be scanned in, separately titled, and then saved into an electronic PDF file. That sounds like that should be easy, but actually I'm finding that it takes longer to construct the electronic bundle than the old-fashioned way with the paper. The other thing is that because of COVID restrictions, every single witness, every single person in the tribunal who's involved is going to have a separate copy of the bundle. So in the past, perhaps you might have had 5 or 6 copies. Now you could be talking, 7 to 12, 15, however many witnesses there are involved. So a lot more photocopying potentially. One of the things that we've seen in recent years is a lot more people representing themselves in the employment tribunal, and of course that the system is designed for that. It was always intended that people would do that. But when you're dealing with somebody who isn't a legal specialist, you do tend to get much more email correspondence from that person than you would from a legal representative. Had a case back in July where I was probably getting 10 emails a day from somebody. Now, they're much more likely to involve the tribunal rather than just agreeing stuff amongst ourselves. So there's more correspondence going back and forward to the tribunal as well. They're more likely to send what I call sort of stream of consciousness emails. You can't just ignore that correspondence. Usually somewhere within it there is a nugget of gold, something that we can't ignore, or something that is really useful to us because it's telling us perhaps how that claimant intends to fight their case, and it helps us then to prepare the defence. But it just shows how these things are sort of mushrooming exponentially. The other thing, of course, is the further away a tribunal is, for every week or every month that it takes from the start of litigation to the end of the process, there's a vacuum, isn't there? And there's the opportunity for everyone to talk a lot more, argue a lot more, correspond a lot more in that space. Whereas if something was listed fairly quickly, then obviously that curtails the ability for that to happen. The other thing that I'm seeing is that gone are the days where we could leave it as to whether we were going to book a barrister in for the end of the process, and wait and see what happened. Maybe the claimant will withdraw their case. That happens in a third of all cases. Maybe there'll be some kind of settlement. Because of the time scales now with everybody's diaries as a result of the shift, it's no longer the case that you'd be able to guarantee somebody be available at short notice like we used to in the sort of good old days. So as a result of that, really we need to be more organised and get dates in the diary as soon as we have them from the tribunal. Chambers have changed their policies as well, so you're much more likely now to receive a schedule or dates when part of a barrister's fees would become payable. So perhaps a week in advance 100% of the fee would be commanded, rather than waiting to the actual day of the tribunal. So even if something settles at the door of the court, you're still going to have incurred the fee. Maybe 2 weeks before, you'll have incurred 50% of the cost, and so on. So again, you can't just leave everything, put it off and think, we'll worry about this nearer the time. There are good reasons for cracking on with preparing cases early doors. Hope that's useful. If anyone's got any questions, please don't hesitate to contact me. It's adenton@refreshinglawltd.co.uk. Thank you very much.